Hi Warriors. This video is for U.S. government, and we're going to talk about another Supreme Court case. So you want to turn to one of these blank Supreme Court case note pages in your book, and we'll begin. The litigants in this case should be listed as Miranda versus Arizona. Miranda is spelled M-I-R-A-N-D-A. That's a man's last name. And Arizona, of course, refers to the state of Arizona. The Supreme Court case was the Supreme Court's opportunity to review a criminal case that began in 1963. So your criminal case was 1963. The Supreme Court case was decided 3 years later in 1966. In regard to historical context, what we want to realize together that in the early 60s, there were attitudes toward people who had immigrated to this country in much the same way, unfortunately, as there are attitudes, negative attitudes toward immigrants in our country today. The constitutional issue at stake in this case comes from the Fifth Amendment. And in the Fifth Amendment, we read that no one shall be compelled in any criminal case to be a witness against himself or herself. So to compel someone is to strongly urge them or to try to convince them to do something. So the Fifth Amendment says that no one can be compelled or persuaded strongly to be a witness against themselves in their trial. There are two players involved in this story. The first is Ernesto Miranda, and he is a 23-year-old Mexican immigrant, as I said before. He's a laborer. He has an 8th grade education. He never finished 9th grade. He is known in his community as someone who is mentally unstable, that his behavior sometimes is unpredictable. The second player in this story is the police department of Phoenix, Arizona. And so the Phoenix Police Department eventually pulls Ernesto Miranda in because he is suspected of having committed a crime. And the way they treat him when they detain him and interrogate him is really at the heart of this particular case. So while we look at the story, there was a young woman who was kidnapped and raped. She reported the crime to the police department. She described her kidnapper and rapist as a young Mexican man. And in fact, she identified, the description was one that fit Ernesto Miranda. The police assembled a lineup, and she, in fact, the victim, pointed out Ernesto Miranda as someone who she thought had committed the crime against her. And so the police went and arrested Ernesto Miranda on suspicion of kidnapping and rape. They took him to the Phoenix Police Department and they interrogated him for about 2 hours. And again, this is a young man who has very little education, a man for whom English may be his second language, and so he was probably not very well prepared to be interrogated by police officers for 2 hours. Eventually, the police officers interrogate him. They tell him that he fits the description given by the victim. They tell him that he in fact was identified in a lineup by the victim, and he ends up signing a confession. He confesses to the crime. That confession is taken into court at the time of his trial, and he's convicted of kidnapping and rape, and he's sentenced to between 20 and 30 years in prison. After that sentencing, Miranda and his representatives decide that he wasn't treated fairly, or he wasn't treated according to the rules or the laws of the Constitution when he was initially picked up by the police, because the police never told him that he could have a lawyer present during his interrogation. They never told him that he didn't have to answer their questions if he didn't want to. And so he was subject to interrogation for 2 hours. And not that television is real life or movies are real life, but we've seen this kind of scene acted out before, where you have a suspect in an interrogation room, and you may have 1 or 2 or 3 different police officers or detectives coming in to interrogate that individual. And there's often an attempt made to bully that person or intimidate them or to catch them in a lie, to lengthen the process so much that they become confused and can't remember how they answered one question or another. And so these kinds of things, it's suggested through the court records and in fact through the Supreme Court's comments later, that he was subject to a number of these kind of interrogation techniques that may have confused or intimidated him. So his appeal against his conviction eventually, to make a long story short, goes all the way up to the Supreme Court, and the Supreme Court decides that they will re-examine his case and see what they think about it. The question then that the Supreme Court has to ask itself is, do the protections that are guaranteed to a person in a courtroom, that you don't have to be a witness against yourself, do those protections extend beyond the courtroom back in time to that place where you may have been arrested or detained or interrogated? And that's the question that the Supreme Court asks itself when they examine the case and begin to argue it among themselves. When it comes time for the Supreme Court to make a decision in this case, they vote, and the vote ends up being 5-4. 5 Supreme Court justices voted with Miranda, saying that he should have been made aware of his right not to be a witness against himself. He could have simply shut his mouth if he wanted to and refused to answer their questions. So 5 of the Supreme Court justices agreed that Ernesto Miranda was mistreated, or the way that law enforcement interrogated him was unconstitutional. 4 members of the court voted against that decision, saying that the Phoenix Police Department was fine, they were not out of line. And so let's look first at the majority opinion written by the Chief Justice of the court at the time, Chief Justice Earl Warren. And let's listen to some of what he said. He said, to protect the privileges in the Fifth Amendment, people must be warned of the danger of incriminating themselves and made aware of rights to representation. So again, he's saying people have to be made aware that they don't have to answer questions if it's going to make them appear guilty or convince the court eventually that they're going to be guilty. And they also have the right to representation. This is what Gideon versus Wainwright dealt with also, that you have a right to an attorney to be present in court to help you with your court case. But now we're looking at, during that time of detainment and interrogation, you have a right to have an attorney present while you're being questioned and interrogated also. Chief Justice Earl Warren goes on to say, after those warnings are given, the defendant could knowingly and intelligently waive those rights. And again, this is language that's similar to language that was written in the majority opinion in the Gideon versus Wainwright case 3 years earlier, that if a person's made aware that they don't have to say anything if they don't want to, they do have the right to an attorney being present while they're being questioned. If they're made aware of those rights and they knowingly and intelligently say, no, it's all right, I'll talk to you, then that's fine, as long as they are aware enough mentally and intelligent enough to make that decision for themselves. Now, as far as the dissenting opinions, often when you have a Supreme Court case that's a 5-4 vote, it's such a close vote, it seems like those 4 people that lost, all of them are a little bit upset about it because they came so close to winning the case, but they were on the losing side. And so often, instead of just one person writing a dissenting opinion, a lot of times all those judges want to write a dissenting opinion. And in this case, I'm going to give you some samples of what 3 different judges wrote in 3 separate dissenting opinions. The first is Justice Tom Clark, and he said, "The majority's opinion created," and this is a quote, "an unnecessarily strict interpretation of the Fifth Amendment." So he's saying, look, you're being too picky. There ought to be some room, some flexibility in here. So that's his argument, basically. We should be more flexible with the Constitution and the amendments to the Constitution. Think what you want about that, but the law is typically treated as sort of a black and white issue. It is what it is, and it is not what it's not. But he's saying, oh, you're being too strict about the way you've interpreted the Fifth Amendment. Secondly, another justice, Justice John Harlan, said the Fifth Amendment does not prohibit all pressure on the suspect. And here we get to the suggestion from the Supreme Court that those officers that were interrogating Ernesto Miranda, that they were putting pressure on him. They were using some of these interrogation techniques meant to be intimidating and frightening. Okay, but Justice John Harlan says, well, the Constitution doesn't suggest that you can't apply any pressure to the suspect. You ought to be able to, push them a little bit. You ought to be able to put a little leverage on them, right? That's his objection to the majority's decision. The third justice, Justice Byron White, wrote that the Fifth Amendment only protects defendants from giving self-incriminating testimony if explicitly compelled to do so. So Justice Byron White is saying, well, the Fifth Amendment only protects them if there's an inappropriate amount of pressure being put on them. And so how are you supposed to decide how much pressure is too much pressure? Again, he's drawing this sort of wiggly or invisible line that you may not ever really know if you've crossed it or not. All right? So these people on the losing side of this vote, the justices who wrote the dissenting opinions, were all saying, look, we don't want this to be such a black and white issue. We want there to be more gray area. We want there to be more flexibility for law enforcement, police departments, to decide just how they're going to deal with these cases on an individual basis. And that was their argument against the majority decision that said, no, people have to be made aware of their rights. They have to be made aware that they can remain silent if they choose to. They have to be made aware that they are entitled to having an attorney present during their questioning if they want one. The ongoing impact of this case on society is that law enforcement now nationwide has to treat every individual the same. They cannot detain and interrogate a person or question a person without first letting them know what their rights are. And that's why this Miranda warning, a specific little speech, has to be given to each suspect at the time of their arrest or prior to their interrogation by police officers so that they know they have the right to remain silent, they know they have the right to an attorney if they would like to have one, and they're also going to be asked, do you understand these rights as I've read them to you? And if you understand these rights, do you now want to talk to me? And the suspect at that point is free because of this case to say, no, I don't want to answer your questions at this time. I would like to have a lawyer sit with me first before we go into an interrogation environment. So that greatly impacted going forward the way that law enforcement was able to deal with suspects that they wanted to question. That's it for this Supreme Court case. I'll see you next time.